I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today I am bringing you compilation 110. We will be in 3 different judges' courtrooms on today. And the first judge courtroom that we will be in, and I will name who that judge is in a second, that is actually a recent case that just happened about a couple of days ago that we're adding to this compilation. But before I give you the rundown on those judges, just know there will be no commentary added to this compilation. There will be chapters added for your convenience. Don't forget to like, share, comment, and subscribe. It is definitely appreciated. Now, let me give you the rundown of these judges. First judge courtroom that we will be in will be that of Judge Sylvia Holmes out of the state of Texas. And like I stated before, this is a case or a proceeding that happened a couple days ago. Second, we will be in the courtroom of Judge Jacob Stillwell out of the state of Washington. And last but not least, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. As always, guys, I appreciate you for joining me here for these compilations. It has truly been a great blessing just sharing these compilations with you guys, having these conversations with you guys, you know, watching some of these different behaviors and acts and just talking about accountability, everything. It has been amazing. So thank you, thank you, thank you. Keep up the great work. And now let's go ahead and jump into 110.
725 Urban Oaks doing business. Urban Oaks versus Jose Martinez, Nicole Lewis, and then the other occupants of 6725. So who do I have on behalf of Urban Oaks?
Keith Wolfshall, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Do I have someone for our first defendant, Jose Martinez?
Yes, we're here as a special appearance only, and Nicole is also in a special appearance as well.
All right. Mr. Martinez, what is the reason you're saying it's a special appearance?
This is a special appearance because we are challenging jurisdiction and we do not participate in legal contract.
Okay. What is the reason you don't think the jurisdiction exists?
Because it has to be proven. Whenever there's a challenge.
That's not a jurisdictional thing. Jurisdiction is either it's something I can't hear, but evictions are solely the province of a justice court. So the only other jurisdictional issue would be if the property is not located in the precinct. To your knowledge, does that address physically fall within the bounds of precinct 3?
I don't believe it does. That there's no personal jurisdiction. There's no personal jurisdiction. There might be subject matter, but in order to hear a case, you have to have subject matter and personal jurisdiction at the same time.
Mr. Martinez, if you're appearing in court, you've been served, and if you are indeed an occupant, then that would be sufficient for them to have personal jurisdiction and for the court as well.
That's why we're challenging jurisdiction. And the law says that whenever we challenge jurisdiction, that the court cannot proceed unless they provide to us, both of us, Nicole Lewis and Jose Martinez, proof that y'all have any jurisdiction.
All right, well, I'll take the information from Urban Oaks, but we'll find out. All right, then. Mr. Wolfshall, please tell me first, why don't we address the jurisdictional issue? Is this property located within the bounds of precinct 3?
According to the maps of Travis County, yes, Your Honor, they are.
Internet just like a hall. I can't hear
the maps.
Mr. Wolfshall, I was not able to understand you. You broke up a lot.
I'm sorry, Your Honor. Is this any better?
That's better. Okay. Tell me about location. Is it in precinct 3?
My apologies, Your Honor. Can you? Okay, thank you. Yes, Your Honor. According to the maps of Travis County, the precinct, this property does lie within the precinct of precinct 3, jurisdiction of precinct 3. We'd ask the court to take judicial notice that 6725 Urban Oaks is in this precinct.
On Circle Road at Congressman William Cannon? Mr. Wolfshall, is that the address?
I'm sorry, Your Honor, you're breaking up on me?
Is the address 6725 Circle Road?
I'm sorry.
Mr. Wolfshall, your internet
I'm sorry, Your Honor.
Is bad.
I'm sorry, Your Honor. The address is 6725 Circle S Road, Austin, Texas, 78745.
All right, I pulled it up on the map. That is within precinct 3. So we have both personal jurisdiction and subject matter jurisdiction. So Mr. Martinez, Mr. Lewis, I do find that jurisdiction exists within our court. All right, Mr.
We
Wolfshaw,
we
what's
don't
the,
that.
I'm sorry, sir?
We don't consent to that unless it's proven to us in writing that there is jurisdiction.
Mr. Martinez, I'm saying that I found proof sufficient. You can appeal if you don't agree. Okay?
Well, no, that's not the law. The law says that we have to go
It is the law, Mr. Martinez. As long as you are showing up, the plaintiff need only show me that they have served the defendant in the result, which you've not denied that you are Jose Martinez. He has established for me that is an eviction wholly within the precedence of a justice court, and that the address for which the eviction is sought is one which is in my jurisdiction. That is all that is needed.
But also it says that we don't participate in legal contract, and that would be.
Mr. Martinez, are you currently residing in the apartment they're trying to evict you from?
I don't understand your question, and I don't understand your jurisdiction.
Mr. Martinez, I'm going to ask that you just be silent and let me go through the plaintiff's case, and then I will answer all of your questions for you. Okay? All right, Mr. Wolfshaw. So it's an address that's in the precinct. What's the reason the eviction's being sought?
Your Honor, this is an eviction for non-payment of rent.
Non-payment. Is there a written contract with the defendants?
There is, Your Honor. It was entered into on November 6th, 2024, and it expired on October 31st, 2025. We're now in the secondary phase.
Mr. Wolfshaw, is that contract with Jose Martinez and Nicole Lewis?
It is, Your Honor. There is a copy that was provided to the court as well.
How much is the monthly rent per that lease?
$1,464.
All right. Any subsidy?
It is not, Your Honor.
Mr. Wolfshaw, you broke up. Was that a yes or a no?
No. The last question is, it is not subsidized, Your Honor.
All
It
right.
is not subsidized.
What months of rent have been unpaid?
October through the present,
Is this a CARES property?
it is, Your Honor.
And when was the notice provided?
September 10th of 2025 I apologize, Your Honor. I did not write that down. Give me just one moment. Let me make sure I'm telling you the truth. All right. It was by first class and certified mail on September the 10th, 2025. It was also a 30-day notice to vacate.
All right. And to your knowledge, the tenants have not vacated?
They have not vacated, Your Honor.
All right. What unit number is it, Mr. Wolfshaw?
Yes, Your Honor. That is going to be unit 1240.
All right. Mr. Martinez, Ms. Lewis, good morning. Mr. Wolfshaw says that you have a lease with the apartment complex for unit number 1240, and he provided me with a copy of that lease. Do you recognize this document?
Yeah, that contract is expired.
Is this a contract that you entered into, Mr. Martinez?
That's not the original one. The original one was signed in wet ink. That one is signed by electronic signature.
All right, so you have a contract that you signed. Is it for the apartment number 1240 there at 6725 Urban Oaks?
It was, but it's expired.
All right, are you still currently residing in unit 1240?
Yes, we are.
When's the last time you paid rent?
I'm not sure.
All right, the landlord here says that the rent is $14.64 a month. Is that correct?
I'm not sure because we were getting assistance from a foundation for the
Per
home.
your lease, what does it say in the lease that you said you signed? On this one, I see it to be $14.64.
Right. That's probably the foundation was paying for that. So they were the ones that were doing all the paperwork for us.
Do you have any proof that they are paying the rent on your behalf? Because the lease says that y'all owe it.
Yes, we do have proof. They were sending checks from City of Austin Foundation for the Homeless to the apartment complex that they were paying the rent.
All right. Do you know if rent has been paid for October?
I'm not sure.
Ms. Lewis, do you know if rent has been paid on behalf of October?
I'm unaware.
All right, and Mr. Lewis or Mr. Martinez, Ms. Lewis, have either of you made payment, or do you know if payment has been made for November?
We're not sure.
All right, well, they do find the landlord has met their burden then to show that per their information in the ledger and the lease, rent remains unpaid for the past 2 months. Mr. Wolfstrom, are you wanting to prorate the rent through the hearing or through the appeals deadline?
Your Honor, just for today, I calculated that as $3,028.
All right, so you are prorating?
Yes, Your Honor, we're prorating.
Today is the 18th, so for 18 days, I got $48.80. So that's 87 or $878.40. So with that and the 1464 for October, judgment for the plaintiff, $2,342.40. If either party wishes to appeal, we'll put that at just the 1 month of rent. That'll be $14.64. Ms. Martinez, Ms. Lewis, you both have at least 5 days to appeal before the landlord can seek a writ of possession. We will send you the information related to that. I'll highlight for you, for all parties actually, in a non-payment case, you may be able to appeal, and if you've been receiving assistance from a rental agency, you might even qualify to appeal for free. However, if you want to stay in that apartment while the case is being heard to another court, you do have to pay full rent of $14.64, but you pay it to the court, and we'll send you specific information about that. All right. Any questions, Mr. Martinez, Ms. Lewis?
Okay.
Can you talk about that?
Yeah. We also submitted a VAWA case, Violence Against Women's Act, that was also violated back in July. And we submitted the VAWA Act. So they're in violation of the VAWA that prevents us from being evicted according to VAWA Federal Act. And we submitted it and they did not respond or help us on that VAWA Act.
All right, Mr. Martinez, unfortunately, that does not work as a defense to non-payment. I would absolutely encourage you to reach out to legal aid with that issue and with the others and see if they can assist you. You have at least 5 days. If you take no action sooner, day 6, the judgment becomes final. All right.
We don't accept or consent to the law, the orders. So
All right. Well, Mr. Martinez, whether you
It's
consent
our
or
record.
not, that is the order of the court, and it will become final, and the judgment would be sufficient for the landlord to move forward with a writ of possession and removal of you and your property. So please contact legal aid in the next several days to see about an appeal. All right.
well, we don't call it legal aid.
Good luck. All parties are excused. Thank you.
All right, next we have Leonard Blatt. Morning, Mr. Blatt.
Morning, pleasure to be here.
So, Mr. Blatt, you filed various motions to dismiss the driving with suspended license 3rd degree against you. I've read all of it. Again, we are getting kind of late in the morning here. Is there anything you'd like to say that is different from what, or that you'd like to highlight from the motions that you filed?
Well, first, may I ask the court to identify yourself and the prosecutor?
Certainly. I'm Court Commissioner Jacob Stillwell.
Uh-huh.
And
Prosecutor today is Ford Libby, Rule 9, supervised by Rosemary Fitzgerald.
Okay. Yes. When the officer stopped me, he asked me for paperwork and simply accused me of a paperwork violation. He asked for 3 things: license, proof of insurance, and registration. Anyone who's engaged in a potentially hazardous activity like operating a motor vehicle has to have his paperwork in order, especially insurance, because he can cause damage with his car. Excuse me. Same thing is true with yourself, because being a judge is a potentially hazardous occupation because it involves violence. No one can be put in a jail cell without unwanted touching. And a lot of damage can come to people if a judge does something wrong. And as a person who has been through a family court and witnessed how unprofessional and out of control the judiciary is here in Washington, and I think you know that the reputation of the legal system in Washington is very bad. I mean, even at one point, the federal government had to come in and supervise and babysit the police because they weren't being controlled.
so I'm going to just try to frame what I'm looking for. Because again, I did read what you briefed. And so maybe it would be helpful if sort of I outline my thinking here. I'll give you a chance to respond. I'll give the chance for the city of Tumwater as well to weigh in here. But let me just kind of start where I'm at. That sounds good.
Sure.
All right, because I know a lot of your arguments are sort of based on sort of overall authority to enforce these laws against you. So I'll sort of start there, right? The Revised Code of Washington, which is the state legal code that is applicable here to criminal offenses related to driver's license. It provides at RCW 4620-342 that it's unlawful for anyone to drive a motor vehicle in the state while the person has a suspended or revoked driver's license. The allegations against you is that you were driving a motor vehicle on a public road with a suspended driver's license. Now, those are still allegations against you. That hasn't been proven. But the city of Tumwater is within its authority to pursue that prosecution because you were allegedly driving a car with a suspended license. And so I know you've raised a number of concerns around that. One of them being, right to travel. You have the right to travel. You don't have a right in any particular mode of travel. So driving a car does trigger certain legal requirements.
Excuse me. I've been in this court already, I think this is the 5th time, and each time I've heard the judge make the arguments that the prosecutor is supposed to make. In other words, the judge has been prosecuting. May I get back on track, because I was making a point. I was heading toward a point when you asked to interject.
Sure.
Okay, so we need to take care of some preliminary matters first. Just as I had to produce paperwork when officer saw me what he believed to be engaged in privileged activity, you need your paperwork in order too. And I just need to verify that your paperwork is in order. I am eager to argue my motions, and I'm eager to hear the prosecutor's response. But first, we need to know if you have your license to operate, which is your oath of office. That's analogous to a driver's license. It's because nobody has a right to be a judge. It's a privilege. And also your bond, your official bond through a surety company is analogous to an insurance for a driver. Because if I'm injured in the course of these proceedings, I need to know that I can be compensated. So
you're welcome to file a public records request asking for any documentation around my authority as the court commissioner or anyone else's.
Right, and I couldn't do that because I didn't know who would appear today as a judge. I mean, I asked before and I couldn't get a clear answer. Also, your bond is supposed to be filed with the county clerk. And with your permission, I mean, I want to make it easy for you. Don't want to make you produce it for me. I could go around the corner to the same building here and verify that your bond is filed with sufficient sureties.
So we're not going to do that today for relevancy purposes here, because what's relevant here is not anything related to me. It's related to allegations against you driving.
It absolutely is relevant to you because it's all about whether you have jurisdiction, and you don't have jurisdiction without your oath of office timely filed and a bond with sufficient sureties. And I have a pocket brief here that I'll give you the court and a copy to the prosecutor to show you.
I'm going to stop you again, and I don't mean to interrupt here, but you have the opportunity to look at those documents. If you're able to find documents in any way, indicating that we don't have the proper authority here to operate as a court in this case, you're welcome to get those documents and present them. But we're not, during the course of the prosecution, going to chase down every indication without any supported evidence that something's amiss here. So if you have something through a public records request, you're able to bring it, but we're not going to chase down all of those arguments as they pop up. We're not going to play whack-a-mole necessarily with arguments being made without evidence.
So if I've told the officer who stopped me that I have a driver's license, I have insurance, trust me, it's your job to go look for it, not mine to produce it. What do you think he would have done?
Well, I don't know. I wasn't there.
Well, we all know what he would have done. He would have said that don't cut it.
So these are all comments that you made in your briefing. So I'm going to, again, remind you, I've read those arguments that you made.
I'm going to give a copy of my pocket brief showing that the judge and prosecutor both require bonding and insurance. And I'll, with your
And
permission,
if you have evidence that there hasn't been proper bonding, you can certainly
I'm
bring it.
giving, well, that's my evidence, my testimony here.
Well, you're not alleging it hasn't happened.
I am alleging it hasn't happened.
Whatever,
I am alleging that.
whatever.
With your permission, I'll give the court a copy of the pocket brief I just gave to the prosecutor.
Sure, but then I'm going to turn it over to the prosecutor to have an opportunity to respond.
Isn't it my turn to present my motions?
Yes, and you have, and you.
No, I have not.
You have. You've provided written motions. You've been given some time to sort of summarize what your arguments are here. So we also want to hear from both sides.
I need to make a statement for the record so the appellate court can understand.
Well, it's 11:33. You got till 11:40, and I'm going to turn it over to the city time.
Well, if the prosecutor wants you to take 3 months out of my life, you have to give me enough time because the taxpayers are going to pay for this. You see, when the officer first stopped me, it was mistakenly thought that I would pay the $66 fine or ever how much it is. And what's going to happen is the opposite. The plaintiff is going to house me, clothe me, feed me, take care of all my needs, medical needs and everything. And I'll get to watch television. I love to watch television. And I love to kick back and relax. And that's what's ultimately going to happen. But we're going to go through due process first. I won't be denied due process. So every district judge, this is RCW 3.34.080. Every district judge pro tempore, and district court commissioner shall, before entering upon the duties of office, take an oath to support the Constitution of the United States and the Constitution of the State of Washington. And as far as bonds, every judge of a municipal court, before entering upon the duties of office, shall take and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Washington. The judge shall also give such bonds to the state and city for the faithful performance of the judge's duties as may be by law, ordinance, or directed. The prosecutor's bond, every county official before he or enters upon the duties of his or her office shall furnish a bond condition that he will faithfully perform the duties of his or her office. Prosecuting attorney shall file it in the amount of $5,000 with sureties to be approved by the proper county legislative authority. Tumwater police officers also have to have a bond, and that's RCW 35A.12.080. As far as, so it's very, very important. It's not just a joke or something that's not important. It's very important that you have an oath of office on file, because from what I've observed in this court and many, many courts throughout the last 40 years living in this state, that judges hate to follow the Constitution. They despise it. So I need to ascertain that you have a timely filed oath of office. Now, I did make a public disclosure request for all the judges that might be operating in this court, and I have them here. I want to make sure your name is on it. I have an oath of office for a John Tunheim. It's not you, right?
Remind you to, you've got till 11:40, it's 11:36.
What if it takes longer?
Because sir, I'm telling you again, I've read what you've written, and you're frankly not making arguments that are relevant to your prosecution. So you're allowed to speak, but unless if you have evidence and if you have evidence there that you wanted to present to the court, you should look at it beforehand and then make an allegation.
I did.
Well, you're reading through the response to your Public Records Act.
You said I should make a public disclosure request for your oath of office and bond, and that's what I've done. And here I'm going through it.
Right, you should go through it before the hearing.
Well, I didn't know who you were until I just sat down here.
Well,
I didn't know who the prosecutor was.
Your Honor, I don't want to belabor the point, but just to make sure that we're being as effective as possible here, this just falls outside of the scope of today's hearing.
I know.
No, it does not, because my brief addresses the importance of obeying the Constitution of the United States and the state of Washington.
And I can tell you, I have my oath of office. I took it a couple of weeks ago. Granted, I'm newer here, but I took it in this very room.
Well, I could not find it unless it's here, because I was given all the oaths of every judge that could possibly be working here. That's what I requested. I also have an oath of office for, it's John Tinham again. He gave me a few of them.
We are
As
gonna
far
turn
as
it over at
bonds-
11:40, just so you know.
As far as bonds, Joel L. Lapierre is supposed to have a bond. That's not you though, right? What is your bonding number?
I don't know. Top of my head.
Okay, so before we can proceed, we have to take care of this preliminary matter.
That's not true.
Well,
You are welcome to bring evidence that I'm not a correct judicial officer for this, but again, we're not going to play whack-a-mole.
well, you're supposed to prove it to me,
That's
just
not
like
the
I was
case.
supposed to prove it to the officer that stopped me, that my paperwork was in order before engaging in a privileged activity.
I certainly believe that, but that's not the law.
You don't, can you cite the law then?
No, you're asking me to cite a law that doesn't exist. A judicial officer does not need to present their bonding number to every defendant.
But you need to have a bonding number, and we've determined that you don't. I requested the bonding information and the oaths of office of every judicial officer that could be working in this court, and they gave it to me all here, but your name doesn't appear to be on it.
Well,
That's prima
Is there-
facie evidence that you don't have an oath of office or bond.
okay, well, then you can file a motion on that specific question if you'd like, but you've got 2 more minutes for this morning.
Okay, I'd like to file that motion right now.
You don't have it. You got to go file a motion.
I can make a verbal motion. I can make it orally. Do you want me to find the RCW, the statute that allows me to make it orally?
Sure, and then you can go and you'd have to, well, I can't give you legal advice, but.
You gave me a lot of legal advice
I'm
today.
explaining what the law is.
The
I'm not
prosecutor
advising.
said nary a word.
You got one more, well, because we've been giving you a chance to speak, and you've got 1 more minute before we're turning it over. to the prosecutor.
Well, I have to determine whether we have jurisdiction here.
That's not up to you.
Well, it's up to you, but you're not making a decision on it.
Because we do have jurisdiction. I'm telling you, I have an oath of office.
But that's not enough. Me telling the police officer I have a driver's license is not enough.
The allegations that you did not have a valid license.
Yeah, a surgeon telling his licensing authority, I have a license, without proving it is not enough. We have prima facie evidence here that you don't have an oath of office or bonding. And the Constitution, you say you have an oath of office, well, that means you swore to uphold the Constitution. And the Constitution requires you to have an oath of office timely filed. And RCW Title 42 says if you don't have it timely filed, you're not lawfully in office. That means that you can't preside over this hearing.
And to the extent you want an answer right now, I'm denying that motion. If you want to file something in writing that goes into that in more detail and provides some kind of evidence that I don't have authority, you're able to do that. I don't know when you made your public records request. It might have been before I took my oath of office, but we're out of time for your arguments at this point.
How do you spell your name?
S-T-I-L-L
S-T-I-L-L
W-E
W-E-L-L.
L-L. First name Jacob with a C.
Okay. I'm going to not participate in an unlawful hearing. So I'm going to go over to the clerk's office and try to get your oath of office and bond. And if they have it, I'll be back here and let's proceed. I'm actually eager to do so.
Well, we're gonna have to file a motion. We're not gonna probably be here anymore when we come back. We close up at noon.
You don't operate after lunchtime at all?
Now the calendar is gonna end at noon. So if you find something, you can file a motion, but we're not gonna stay open just so you can go do your public records.
Okay, well, I came here at 9 o'clock because I thought things would start then and I had to endure watching all this.
Sir, we're out of time at this point.
So that's what I'm going to do because I'm not going to participate in an unfair hearing where there's no jurisdiction. I will
So
file
those
another
are
motion.
your final comments here, because we gotta move on.
My final comments are this. We're going to assume that you don't have an oath of office timely filed or bonding, so you can't proceed over this hearing.
If you can
It's
go get
simple.
evidence of that, you can come back, but until then, we're gonna, unless the prosecutor has anything to say.
Okay, so then since I object,
Sir, I'm moving it over to the prosecutor.
so since I'm wait, I have a right to make my motions. I have a right to argue my motions. I brought this hearing.
I understand.
Not the
We're going to
prosecutor.
move on.
I brought this hearing, not the prosecutor.
We're going to move on.
So I'm going to ask you to recuse yourself since you're not well.
All right, well, if there's been a request for recusal, perhaps I won't be here at the next hearing, but that's going to be it for today, okay? Here to go. Well, sir, we're also here set for trial confirmation. You have a jury trial set.
I haven't even answered the plea yet.
Well, you don't have, I mean, the state is moving forward. Probable cause has been found. You've elected to represent yourself against.
I am myself. I don't represent myself. I am myself.
Well, are you ready to proceed to trial on November 17th?
First, I have to be advised of the nature and cause of action and enter a plea. And I have to verify that the judge, which keeps rotating, is lawfully in office. I mean, I'm not trying to throw monkey wrenches in this or anything or give you a hard time. I'm just trying to require due process.
You were arraigned on June 26th, 2023. Determination of probable cause was found.
Your Honor, just to,
Well, you said I'm free to leave and you're not lawfully in office, so I'm going to leave.
well, Your Honor, if the defendant's going to walk out, I would request a bench warrant be issued if he's just going to walk out of his own trial confirmation.
All right, sir, are you here with him? Is that the two of you speaking?
I'm hard of hearing.
I was asking if the two of you were here together.
I can't hear.
Were you here with Mr. Blatt?
I don't have a case here.
Okay, were you here with Mr. Blatt, who was just up here?
I can't really hear you. I'm getting a hearing.
Why are you here?
But I haven't had all the tests yet.
Okay. Why are you here in court today?
Oh, I'm just here to observe.
With Mr. Blatt?
Very interesting.
Okay.
I watched the body language.
Okay.
I watched the behavior panel on YouTube, and I'm watching this video to watch the body language.
All right. Thank
Very
you, sir.
interesting.
Okay, thank you, sir.
Can I go
You're free to
now?
go. Yes. All right. So the request is a bench warrant for, I don't know if I can issue a bench warrant for failure to appear. If he doesn't show up for the jury trial,
Okay.
I think at that point, there might be grounds, but.
So then I guess the state would just ask to keep the trial dates and proceed from there. And Your Honor, I believe you were clear, but just for the record, I know there's been a lot of talks about public records today. If we could just have a ruling on the defendant's motion today.
Yes, to the extent I wasn't clear, I'm denying the defendant's motions to dismiss all of that have been filed, and trial appears to have been confirmed. There's no unequivocal suggestion to the contrary, so we'll keep the jury trial dates as currently set.
Your Honor, the state would request that the court still order the panel at that. We would ask to go forward with the trial date at that time. If the defendant is not present for the trial date, the state would likely renew its motion for a warrant.
Right, that makes sense.
Thank you, Your Honor.
All right, let's see.
All right, so I don't think that Mr. Where's Mr. Grigsby's spot? Say Kingsbury. Do you want an attorney, Mr. Grigsby?
No, sir.
I didn't think so.
I'm not, excuse me, I'm not, again, I'm in special appearance of Contrail Grigsby, and no.
Well, I need Contrail Grigsby. So whoever, if you're not Contrail Grigsby, then we're gonna put a warrant out. We're gonna put a warrant out for your arrest.
Well, I'm in special appearance of Contrail Grigsby, and whatever.
Right, so I have Contrail Grigsby.
Like I said, I'm in special appearance of Contrail Grigsby, and I do not need an attorney. And he do not, do not need an attorney.
City of Detroit versus Contrail Grigsby, case number SP 168-33921. SP 1683393, counts 1 and counts 2. Appearance for the record, please.
And special appearance of Contrail Grigsby Jr., Shuri Juris and Proprio Persona.
That went over my head.
No rights. I do not waive no right, none of my rights.
All right, Woody is today is the date and time set for a pretrial. What do you want to do with these cases?
Should be taking it. First, I want to I've added 2 pieces of documents to the court. I want to put them on a record. My affidavit of conditional acceptance and my Naturalization Act of 1779 I already had on the record. So
I want to take it. You don't see this phone? All right. What do you? Okay, that's on record. What do you want to do with these cases?
I'm fighting.
All right. So you want a trial date?
Yes, sir.
I'm going to give them a jury trial date. Let a jury of his peers determine whether his innocence or guilt. Jury trial date, please. In person. The trial date will be in person.
Jury trial. Can handle this. Can this right be handled in private? I request that my this be handled in private. I don't
know what you're talking about. All court appearances are public.
Yeah, all right.
Let's pass it. We're gonna get a jury trial date, and we'll go from there. And all the parties must appear. You don't have to be in person on that, but I want the officer to appear as well, because we want to make sure there's a lot of noise in the background. Somebody's got a lot of noise. That's going to be it. I think that might be your background, Mr. Mason. But I want to make sure that that we don't order a jury, and it's not going to be actual trial. So June 9th, final pretrial. June 10th, jury trial. That will be in person. And for all the parties.
Is there since you said you don't have my documents, is there like a way that I could personally send them to you? Like, can I get like an email or something?
You can bring them down to the court.
Okay, cool.
You need to file them the proper way.
Yeah, I came down. I went down to the Coleman Young building. And then they said this is not a felony case. They sent me to 36th district, and 36th district said do it, online. Well, I did it online in like April.
It's online. Maybe it's in the system somewhere. You can always drop a copy off with always drop a copy off.
If I may, Your Honor, if I may interject, Your Honor, I'll give Mr. Grigsby my email, and we can communicate through email. Mr. Grigsby, I'll put this in the chat for you, okay?
Yes, thank you. I appreciate you.
You're welcome.
And the court's going to need a copy as well, an original copy, so that'll be. Mr. Grigsby, you have the dates, right?
Okay, I got a date, but no time.
8:30 for the pretrial.
8:30.
And it's going to be 9 a.m. for the jury trial.
9 a.m.
June 10th. June 10th. So come
June 9th.
June 9th at 8:30 and June 10th at 9 a.m.
All right, and you said I could drop it off down at 36th District Court. So who do I bring it to when I come down there?
You can bring it to the courtroom and bring it to the clerk.
All right, court 434.
All right. And if there's nothing further, any
And
further
Mr.
questions?
Hold on, Your Honor, if I may, Mr. Grisby, I just put my email in chat for you, so you can email your documents for the prosecutor's office. You can email the prosecutor's office at Dia Mason okay?
Yes, thank you. I appreciate it.
And we will send our documents to you when you email us, so we can email you as well.
Okay. DIA Mason at Detroit. DETROY.
All right, if there's nothing further, sir, have a very good day. Best of luck to you.
You're all set.
You as well. Peace and love. Thank you. I appreciate y'all.
Thank you. City of Detroit versus Contrell Grigsby, case number SP 168-3392. SP 168-3393, counts 1 and counts 2. Appearance on the record, please. For the record, please. Mr. Grigsby. No.
Junior.
I don't believe that's, Mr. Berry, I don't believe that's necessary. I don't know, Mr. Grigsby, do you want representation or no?
No, sir.
State your name for the record, please.
Special appearance, Contrell Grigsby.
Okay, good morning to you, sir. Today is the date and time set for a final pretrial. Where is Ms. Harris? Ms. Snyder. Ms. Snyder, are you here? We need to Contrell Grigsby's file, please. Set for a jury trial tomorrow.
Can I ask a question?
You may.
Since the last time we spoke, you told me to just bring all my paperwork down there. I wanted to see that you received it. I had brought it down to the courtroom.
I don't really know if it's going to be necessary. I also told everybody that all parties need to appear, and as their whole Valenstein is here. So no, I didn't get any of your paperwork that I have at the moment. Do you have Contrell Grigsby? No. And what should I expect to see in that or read in that paperwork?
Should I brought my fee schedule down there. I made me an affidavit, conditional acceptance, and I brought a few things down there, and I had sent them. All right.
Go ahead.
I had last time we talked. You had gave me a lady's email address, and I also sent all the paperwork to her email address.
That's probably Officer Valenstein. Good morning to you. Can you? We're on the record with Mr. Grigsby. Can you state your name, department and badge number, please?
Yes. Good morning, Your Honor. Officer Valenstein, Detroit Police Department, badge number 4744.
All right, very well. Today is the date and time set for a final pretrial. So we do have all the parties here. There's going to be a jury trial tomorrow. I'm imagining that trial is going to go. I would like to have Ms. Schneider here to make sure that you two agree on any jury instructions. I don't know if you've made any, if you've gone over any jury instructions and have an agreement on the jury instructions and things like that. Or we'll just read the instructions as they are listed in the, if you have not. So I'm gonna wait until Ms. Schneider comes in. Mr. Grigsby, I'm gonna put you in a breakout room with Ms. Schneider. You two can have that discussion. And then we'll get you out of here. I'll wait till she comes back. We'll get you out of here after you talk to Ms. Schneider about how you two are gonna proceed, all right?
Okay, cool. Yes, sir.
All right, let's pass the matter. And that's in person tomorrow.
Yes, sir.
All right. Let's go back on the record with Mr. Grigsby. Ms. Snyder, can you put your appearance on the record, please?
Morning, Your Honor. Alexa Schneider for the people, P80322. The issuing officer is present.
Yes, I've already spoken with him. So have you and Mr. Grigsby spoke about procedure tomorrow?
Yes, Your Honor, we did discuss it. I sent you a chat. Mr. Grigsby has not prepared jury instructions, but he does have a civil infraction along with his misdemeanors. I talked to the officer. We're going to dismiss the 2 misdemeanors. He can proceed with a formal hearing on his civil infraction.
We're not going to call a jury in for that.
Correct.
What about right now? Mr. Grigsby?
Yes, sir.
So you can either pay the 145 and then we'll close it out, or you can have a formal hearing on that. The officer's here right now on the expired.
I'm having I want to have a formal hearing for Mr. Grigsby.
All right, are you ready to proceed now, Officer Valenstein?
Yes, Your Honor.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, it's on you, Officer Valenstein. You want to assist Ms. Snyder or not? I guess not.
Yes, I'm
I'll
all
leave it
for
to you.
Say that again.
I'm sorry, I cut out. What was that, Miss?
I was going to say, I'll leave it to his honor.
Oh, okay.
It's up to you two. I mean, it's a civil infraction of expired plates. Go ahead, officer.
Okay. Back on February 19th, 2025 at approximately 6:29 p.m. I was doing traffic enforcement in the area of Grand River and West Grand Boulevard. I seen the silver Chevy driving southbound on Grand River. I did a traffic stop, or I ran the plate, came back that it was expired. Back on December 21st of 2024, pulled the vehicle over, conducted a traffic stop. The driver, Mr. Control Grigsby, stated that, there was no registration for the vehicle.
So you're saying that he admitted that there was no registration for the vehicle?
As far as I recall, yes. There was no registration to show. I mean, as far as everything else, I don't know if you want me to keep going about the insurance or the display license, but.
No, I don't think that's relevant now, because that's going to be. So basically, on this date and time, you pulled the vehicle over, and the vehicle, for your testimony, the vehicle did not have valid registration, and that you're saying that Mr. Grigsby told you that the vehicle did not have valid registration. Go ahead, Mr. Grigsby, if you want to say more.
Yes, according to
let me swear you in. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth? Raise your right hand, please.
I want to.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
As long as I'm not giving up any of my rights.
No, you're not giving, you're just swearing to tell the truth, whole truth, and nothing but the truth.
Okay, cool.
Say yes or no.
And as long as y'all know I'm in special appearance, yes.
Do you swear or affirm to tell the truth, whole truth, or nothing but the truth?
Yes, sir.
Okay, go ahead.
Yes, sir. According to Michigan law, I'm only supposed to have my license or anything, license, registration, or insurance if I'm doing commerce, and I'm not doing anything. I was just traveling. I wasn't as I told the officer, I was traveling. I'm only supposed to have a driver's license if I'm like making money or doing anything. I wasn't in, like I told him. Same thing I'm telling you.
So you're not disputing the fact that you're not disputing the fact that you didn't have plates on the vehicle, proper registration for the vehicle?
I'm disputing the fact.
I'm asking you a question. I'm asking you a yes or no question.
I'm asking you a question that is.
No, you don't ask questions. I ask the questions.
Well.
So is it
the mutual advice, please.
Did you tell the officer that you didn't have any plates on the vehicle?
I don't recall what I told the officer.
Okay, well, he seems to recall very well. Is there anything further?
Yes.
Go ahead.
Michigan code. As I sent to you, I brung down there and I emailed the lady. Michigan code says that I do not need to register my vehicle. I do not need to have a license unless I'm acting in commerce. And I was not acting in commerce as I told the officer plenty of times. I'm not acting in commerce, so I don't need a license or I don't need to register anything.
All right.
Michigan.
Is that it?
Oh, no. And I sent you my conditional acceptance twice. I sent you all of my paperwork.
I'll let you put it on the record. So I'll let you put it on the record. Is that it?
Yeah, I want to put all my paperwork on the record. Did you receive it?
No, I told you I didn't.
Well, I don't know how. I got the
But in this case, I'm gonna tell you this, I don't have to. Find you responsible, $145. When can you pay?
I'm not paying it.
All right, bye. Have a great day, sir.
Yeah, y'all will be hearing from me. You'll be hearing from me, my boy.
$145.
It is.
I'm not your boy, all right?
You want to be.
I'm not your boy, okay? So don't say too much more, sir. I'm just saying you're free to leave. Have a very good day. All right. Officer Valentin, you have a very good day. Best of luck to you.
Thank you so much, and to your staff as well. Have a great day.
You as well.
I'm not threatening you. Say one more word and that's 30 days. 30 days.